All rise. The International Criminal Court is now in session, hosting the ICC Moot Court Competition 2022, English edition. Please be seated.
Good afternoon, all. I would like to greet the teams participating remotely. Firstly, Counsel for the prosecution, who in our case is the appellant. Counsel for the defendant and the legal representative of victims. I also welcome as well all of those who are physically present in court, the courtroom staff, and the security officers who assist us. I should also like to greet those who are in the public gallery, the participants in the International Criminal Court Moot Court competition attending this hearing, and those outside the court joining us this afternoon via the internet. Court officer, please call the case.
Thank you, Madam President. We are sitting in the appeal session regarding the pretrial chamber's denial of confirmation of charges in the case of the prosecutor versus Agon Megor of the Republic of Ipin, ICC Moot Court Competition 2022 English edition.
Thank you. Now, before we start, even before we make the appearances and the parties introduce themselves, I should like to remind everyone to speak clearly and slowly so that we can all understand. So, on that note, perhaps now we can have the introduction of the parties, beginning please with the prosecution.
Madam President, Your Honors, and may it please the court. My name is Zeyi Huang Raoul, along with my co-agents in alphabetical order: Guo Chen, Ding Kuo, Lü, Di Yun, Shu, Peng Hai, Jin, Shu Chang, Tian, and Shu Ran, Sun.
Thank you, Counsel.
And shall I be seated?
I now turn to the defense team. Could I ask you, Counsel, to present the members of your team?
Your Excellencies, and may it please the court, my name is Brooke Hamby, and I, along with my co-counsel and teammates for Team 100, Mackenzie Rivers, Madison Stemple Pyatt, and Shirley Sheet, represent the defendant, Mr. Agon Magor, in this proceeding.
Thank you, Counsel. Counsel for the victims, please.
Madam President, Your Honours, may it please the court. My name is Sinead Murphy, and alongside my team members, I represent the Counsel for the victims in these proceedings, and my team members are Anya Smith, Barry Donovan, Clina Buckley, and Patrick Flynn.
Thank you, Counsel. And for the registry,
the team of the registry is represented by today the court officers Sofia Aaltosetälä and Inari Elsi, as well as Visti Rakmahan and Ethos Edmir Kadanakis from the Courtius Center for the International Legal Studies.
thank you very much, Registry. And finally, I should like to introduce the bench. To my right is Cynthia Chamberlain, and to my left, Farhan Ahmed. I introduce myself. I'm Althea Alexis Windsor, and I am a judge at the International Criminal Court, and I shall be presiding in this moot. Very well, so that we will now proceed to hear the three issues shaping the subject matter of today's hearing. Before we begin to do so, I would ask the court officer, because this is a public hearing, to read the agenda established by the appeals chamber so that those who are following will be able to do so.
Thank you, Madam President. Pursuant to Pre-Trial Chamber 6's decision to grant the prosecution's request for leave to appeal the denial of confirmation of charges, dated 15 September 2021, the appeals chamber seeks submissions of all parties and participants on the following two issues. First, whether the pre-trial chamber erred in denying the prosecution's request for confirmation of charges pertaining to the defendant Agon Merkor, and second, whether the pre-trial chambers erred in deciding that a single victim's representative was sufficient to represent families of killed adult pirates, as well as the families of child pirates, hostages, and innocent bystanders who were also killed in the counter-piracy operations.
Thank you, court officer. I now give the floor to counsel for the prosecution to present its case and to discuss the issues on the agenda. Counsel, you have 20 minutes. Proceed, please.
Madam President, Your Honors, and may it please the court. My name is Zeyi Huang Raul, along with my co-agents. We represent the prosecution in this matter. In October 2020, the state of Kod killed nearly 1,000 persons in a week by launching a series of deadly drone attacks. And defendant Mr. Mega allegedly provided 2 sets of hunter-killer drones and remote trainings, which were key means to conduct those attacks. However, the charges against him by my office were denied by the PTC in its 15th of September 2021 decision, and our first submission today is to appeal this denial. Our second submission is to appeal the other part of that decision, that contrary to its determination, one legal representative is insufficient for all victims if the case were to proceed. In today's hearing, I will refer to that decision as the impugned decision. Starting with our first submission, we make 3 primary arguments. We organize these arguments in the following order, consistent with the court's practice, such as in the Bamba case. At first, the court has jurisdiction, and the case is admissible with sufficient gravity. Secondly, the evidentiary threshold at the pretrial stage was satisfied. And thirdly, the drone attacks constitute crime against humanity and/or war crimes, and defendant is responsible for aiding or abetting those crimes. Starting with the jurisdiction issue. As held by this court, at paragraph 248 in the Lubanga confirmation decision. Even if an offense initiated prior to the entry into force of the statute, the court can still exercise temporal jurisdiction over it if it is of a continuing nature and continued after the critical entry date. The offense in that case was the enlistment and conscripting of children under 15, which was determined by this court to have such continuing nature. Namely, it continues to be committed as long as the children under 15 remained in the armed groups or forces. And here by analogy, defendant's lease of drones is also of such a continuing nature. Although the lease initiated in July, the act continued to be committed as long as the drones remained in the leased status all the way after August 1st, 2020, when defendant's state of nationality joined the statute. And the court therefore has temporal and personal jurisdiction in this case. Turning then to the admissibility issue, that the gravity of this case is sufficient to justify further action by the court under Article 17(1)(d) of the statute. When assessing the gravity of a given case, the court, such as in its 2020 Al-Hassan appeals judgment, refers to the scale, nature, and manner of commission of the alleged crimes, as well as their impact on victims. And in this case, it is submitted that all the above four factors are supportive, and the scale and manner of the drone attacks are particularly compelling. The scale of the crime mainly refers to the number of victims. And in the registered vessel situation, a confirmed number of 10 deaths and 50 to 55 injuries were deemed by the PTC to have been a compelling indicator of gravity. And the 1,000 deaths in this case, or at least the 300 non-pirate deaths within those 1,000, which were undoubtedly civilians, rises beyond that already compelling standard. And further, it is submitted that none of the above deaths can be justified by IHL, because the drone attacks in this case did not amount to a NIAC, which is most prominently because the pirates did not meet the level of organization to establish a NIAC, since they were described at paragraph 2 of the impugned decision as loosely organized. And their previous victories against the security force, which were not an army, but only police and coastal guards very lightly armed, cannot be said to have demonstrated the requisite military operational capacity as a most significant factor relied on by this court in its most recent confirmation of charges issued last December, which was the case against Mr. Said. Additionally, we noticed that the drone attacks were committed in a manner of particular cruelty, that at paragraph 5 of the impugned decision, you see most victims were burnt in fire and smoke, drowned in shipwreck, or hit and buried by building collapse. And it's particularly for those two compelling factors, along with the other two, that this case is of sufficient gravity. Turning then to our second argument, that the prosecutor has satisfied the evidentiary threshold at the pretrial stage. And in this respect, the prosecution's most concerned issue is that, contrary to the PTC's determination, as well as the defense argument in their written submission, although the news article was retracted by the journalist who wrote it, and he no longer stands for its credibility, this retraction does not decrease the probative value of that evidence. This is because the retraction was highly probable to have been resulted from a systematic witness interference, that the same day after the journalist retracted the news article, he purchased a luxury car far beyond he could afford, which indicates that he might have been bribed. And the other witness involved in that evidence, the security force commander, has disappeared within court's territory for 17 months until now. And it is therefore submitted that before the potential witness interference is properly investigated and eventually confirmed or denied, Your Honors may disregard that retraction from the relevant fact for the purpose of assessing the probative value of that evidence. Turning then to the charges against defendant. First, the drone attacks constitute crime against humanity of extermination. Starting with the contextual element, And the key question presented in this case is that whether the drone attacks constitute an attack against any civilian population. Since there was no NIAC, the drone attacks should be deemed as a governmental law enforcement, and as held by this court in the Philippines authorization, an illegitimate law enforcement violating human rights would constitute an attack against civilian population, such as the right to life as enshrined under Article 6 of ICCPR, that no one shall be arbitrarily deprived of his or her life. And more specifically, the children, even as criminals, deserve additional protection to that right. That every effort should be made to exclude the use of firearm, especially against children, as recognized by the Code of Conduct for Law Enforcement Officials adopted by the UN General Assembly in its Resolution 34-169. And in this case, the drone attacks have arbitrarily deprived the right to life of the juvenile pirates and non-pirate victims. That those attacks made no difference in terms of the level of violence used against the adult and juvenile pirates, and the security force deployed inaccurate hunter-killer drones firing explosive missiles which were unable to prevent damages to hostages and bystanders. And it is for that reason that these drone attacks have violated their right to life by arbitrarily depriving it, and therefore they constitute an attack against the civilian population. Turning then to the specific elements of extermination. According to the elements of crimes, extermination requires that there must be a mass killing. Since the court's only case law concerning extermination so far, the al-Bashir case, did not intend to draw a minimum line for mass killing, we would like to refer your honors to the ICTY Lukik case, where 60 to 70 deaths were sufficient to constitute extermination. And in this case, either the death of 350 juvenile pirates or 300 non-pirate civilians, or both, can rise beyond that standard. Conclusively, the drone attacks constitute crime against humanity of extermination as an illegitimate law enforcement conducted in peacetime. Secondly, if your honors determine that there was a NIAC, in such context, the attacks would still constitute extermination, and in addition, war crimes of attacking civilians and protected objects. In respect of extermination and attacking civilians, the two crimes are similar in terms of the requirement that there must be an attack against
10
civilians.
minutes left.
It is submitted that even in the context of a NIAC, the juvenile pirates were not deprived of their civilian protection, and the non-pirate victims were to be deemed as being targeted instead of incidentally killed. As for the juvenile pirates, as held by this court in Taganda, children under the age of 15 lose IHL protection only during their active participation or direct participation in hostilities. And here, the impugned decision is silent on the status of the juvenile pirates when they were killed, and it was unlikely that they were attacking the security force in those night times. And consistent with paragraph 148 of the Richmana confirmation decision, in such case of doubt, a person should be considered as a civilian. As for the non-pirate victims, as held by this court in Katanga at trial, where it referred to the ICTY Martic case jurisprudence, a direct attack on civilians may be inferred from the character of the weapon used if they are incapable of hitting specific targets, and the subsequent civilian death caused by such indiscriminate weapon cannot be justified as collateral damages. And by referring to this jurisprudence, in this case, the drone attacks were to be deemed as an attack against those innocent civilians by virtue of the inaccurate nature of the hunter-killer drones. And in respect of war crime of attacking protected objects, the destruction of the school and hospital in this case can only be justified if they constitute military objectives, which must make an effective contribution to military need, as customarily defined. And further, pursuant to Article 11.2 of Additional Protocol 2, even if a medical unit was used to commit hostile acts outside their humanitarian function, its protection still cannot be deprived if no warning has been given to that unit. In this case, the school was utilized by the pirates as a hostage detention center, which contributed only to criminal instead of military need. And the hospital did not receive any warning from the security force before it was destroyed. Therefore, the two buildings were not deprived of their protection under IHL and were not military objectives. The drone attacks against them, therefore, constitute war crime of attacking protected objects. Thirdly, defendant is responsible for aiding and abetting the above crimes under Article 25(3)(c) of the statute. As for the actus reus, Article 25(3)(c) explicitly mentions providing the means for commission as a form of aiding or abetting. And in this case, defendant provided the hunter-killer drones, which were key means for the commission of those drone attacks. It is further submitted that defendant abetted those attacks, since the security force did not know that such a secret foreign weapon was available for them to conduct those attacks. And it was the defendant who told them that he was willing to provide with them those weapons as long as they are determined to conduct those attacks. Then as for mens rea, the aider or abetter must have a facilitating purpose for the commission of the principal crime under the text of Article 25(3)(c). And in this case, defendant did have such facilitating purpose, which is in particular reflected at paragraph 5 of the impugned decision, that after the security force commander stated that they wished to eliminate the pirates at all costs, regardless of the civilian casualties and destructions that they have previously discussed, defendant immediately expressed his happiness to provide the drones to them. And not only those drones, but also remote trainings to enable the security force to use them. And by fulfilling these requisite elements, defendant is responsible for aiding and abetting the crimes charged. Turning then to our second main submission, that one legal representative of victims is insufficient in this case. Under paragraph 4 of Rule 90 of the Rules of Procedure and Evidence, the selection of victim representative shall avoid any conflict of interest. And as interpreted and reiterated since Katanga, the wording of shall at that paragraph leaves the court no discretion but to appoint multiple victim representatives if any conflict of interest among victims is identified.
5 minutes left.
In this case, the prosecution observes two grounds of conflict of interest among the victims. First, as held by this court in Taganda, conflict of interest may arise if some victims may have perpetrated crimes against other victims. And in this case, we see the adult and juvenile pirates have perpetrated multiple crimes against non-pirate victims, such as killing, kidnapping, and forcible use as human shields. And meanwhile, the adult pirates also committed crime against juvenile pirates, namely abduction and forcible recruitment into the pirate ranks as an armed organization. And secondly, as for the second ground of conflict of interest, as held by this court in Katanga, conflict of interest may also arise if victims may give conflicting instructions which are irreconcilable to be represented by one legal representative. And here, the families of adult pirates and of other victims may give conflicting instructions on whether to argue the existence or non-existence of a NIAC, and on whether to defend the civilian status of the juvenile pirates. This is irreconcilable because if a NIAC proves to exist, this would trigger the application of IHL, which will justify the killings of adult pirates as members of an armed group. And their families may therefore lose their chance to claim reparations, while the other two groups of victims can still allege themselves as victims of both crime against humanity and war crimes. As for the argument on whether to defend the child soldiers for their civilian status, It is said that these conflicting instructions may be given because of the hatred-oriented relationship between the different groups of families. This is because the adult and juvenile pirates are at least partially responsible for the death of the non-pirate civilians. And it is therefore submitted that these families cannot be grouped into the same. It is for those two grounds that the PTC's appointment of only one victim's representative is inconsistent with Rule 90 and therefore may be reversed. As a closing note, Your Honors, the advanced technologies, industries, and science does not have conscience of its own. And whether it will be used for good or ill depends on man. We urge Your Honors to seize this precious opportunity for this court to express its opinions on the use of such an indiscriminate weapon that it is illegal under international law. And this concludes the prosecutor's submission pending rebuttal. And I would like to take questions from the bench.
Okay, that's nice, Counsel. Thank you. Counsel, I have one question, and my fellow judges also have a question each. You've mentioned the journalist, and you have put forward an argument that we should consider the evidence of the journalist, the proposed evidence of the journalist, as if it has not been retracted because there is some information concerning the bank draft and purchases made and so on. However, you are the prosecution. You are the appellant in this matter. The burden of proof is on your shoulders. Tell us, why then should we consider this evidence in the same way in which we would consider other evidence which has not been impugned?
And if I understand Madam President's question correctly, you were asking that whether we are still bounded by the ounce to prove that the evidence is interfered. And it is submitted that we're not asking Your Honors to confirm the existence of a witness interference, which according to Rule 68 of the Rules of Procedure and Evidence is a legal issue to be dealt with at trial stage, but not now. Instead, we're submitting to Your Honors to request you to disregard the retraction instead of putting any advantage or disadvantage over the prosecutor's position. And I see my time has gone up. May I be given an additional minute to respond?
Yes.
Thank you. And in this regard, it is submitted that that we are asking this court to disregard the retraction and before the witness interference is confirmed. So in this regard, we're not proving any fact. Instead, we're asking Your Honors to not to have regard to this fact.
Thank you. Any question? All right, we have one other question, please.
Thank you, Madam Presiding Judge. I had a question regarding the status of the school that was attacked. Now, according to the evidence that is before us, the school was appropriated by the pirates. There's no evidence, at least in front of us at the moment, that shows that the school was a functioning school. So my question to you would be, why would this school, or the building at least, without the students, without it performing the function of a school, being used by pirates as a base, be considered to be a civilian object and not a legitimate target, whether in a non-international armed conflict or whether in a situation where there is no non-international armed conflict? Thank you.
It is submitted twofold concerning Your Honor's question. First of all, concerning Your Honor's question that you're requiring us to prove that the school was a civilian instead of military building. It is submitted that that the school was not a military building because the school was a hostage detention center which contributed only to the financial support of those pirates to collect weapons, which cannot be deemed as contributing to military functions. And in this regard, we may refer Your Honors to the anti-drug practices in Colombia, in which those production facilities, which has also financed the drug army, were disregarded from military objectives. As for the fact that they were protected objects under Article 82E4 of the statute, it is submitted that by referring to the text of that paragraph, it is required that a protected object, if it's an object to be dedicated to religion, or education in this case. And we does not see from the text that it is required that at the moment of the attack, any students should be inside that building or it should be functioning as a building. And it is protected, and not because it was being used as a school, but because it was dedicated to education. Thank you, Your Honor.
Thank you. All right then, so thank you, prosecutor. Let us now go to the presentation of the case for the defense. Counsel, for the defense, you have also 20 minutes.
Your Excellencies, may it please the court. My name is Brooke Hamby, and my co-counsel and I represent the defendant, Mr. Agon Magor, in this proceeding. This case boils down to a conflict between Karth and the Taivash pirates. When Karth was overpowered and undermanned, it reached out to the more powerful country of Ibn for assistance and protection of its citizens against a dangerous national security threat. It is the defense's position this court should find the pretrial chamber did not err in not confirming charges against Mr. Magor because it reasonably appreciated the facts, and this chamber can come to its own conclusions as to the law for the following 3 reasons. 1, this case is inadmissible and the court lacks jurisdiction to prosecute Mr. Magor. 2, the prosecutor did not meet its evidentiary burden to establish elements of war crimes and crimes against humanity and establish Mr. Magor's individual criminal responsibility in those alleged crimes. And 3rd, if this case were to proceed, one common victim's representative is sufficient to advocate for the needs of all affected victims. Turning to the first point on this first issue, the case is inadmissible under the Rome Statute, Article 17(1)d gravity requirement, qualitative and quantitative criteria as seen in the Al-Hassan admissibility decision, paragraph 57, because the number of innocent victims is too small and the actions taken were in the police power of the state of Karth. The number of victims in the Karth counter-piracy operation is too small because the 700 juvenile and adult pirates were legitimate military targets and cannot be counted as innocent victims, in contrast to the argument of the prosecutor. Customary international law, and this court stated in the Afghanistan investigation decision, paragraph 63, military targets can include any person who makes a contribution to military action, no matter their status. And a victim must be someone otherwise not taking part in hostilities to be included as an innocent victim in the eyes of the court. As reflected on the record, pages 3 and 4, there is no doubt the juvenile pirates were openly and directly involved in all hostilities. This included holding hostages, taking over a hospital, and using medical workers and patients as human shields. As the prosecutor stated in their submission, these both juvenile and adult pirates were criminals. Moreover, the actions taken by the QHSF were within the policing power of the Karth government to protect citizens against national security threats. Article 8.3 of the Rome Statute provides nothing contained within this article shall affect the responsibility of a government to maintain order in its state by all legitimate means. The actions taken by the QHSF in the counter-piracy operations were aimed to maintain order in Karth. The Taibosh targeted not only cargo ships bound for Karth, impacting economic development, but also attacked civilian ships taking hostages, as seen on the record page 3. Over these 3 years of altercations, the Taibosh killed Karth citizens and members of the QHSF, as also seen on the record page 3. Karth took the only logical step of reaching out to an allied country with more resources to combat this growing threat. Leading to the second point on this first issue, the court lacks both personal and temporal jurisdiction over Mr. Magor. The court does not have temporal jurisdiction because under Article 24.1 of the Rome Statute, jurisdiction cannot be satisfied if the alleged criminal acts took place before the state became a party to the Rome Statute, and the Rome Statute cannot have retroactive effect. Moreover, this is not a continuing crime, as the prosecutor has argued, because as reflected in the record, the conduct in this case is instantaneous, and by definition, continuing crimes are based on a series of events which take place over an extended period of time. And the military operations can be distinguished before and after the delivery of the drones. The QHSF was unable to match the actions of the pirates before delivery, but were able to after. There was a significant rise in intensity level in October of 2020 compared to the sporadic attacks over the 20-month war on piracy. Mr. Magor's conduct occurred before any war crimes took place in Karth in October of 2020, as seen on the record pages 3 and 4. The critical date for Mr. Magor's participation is July of 2020. Mr. Magor's conduct and participation in any sort of alleged criminal activity promptly ceased when the drones were delivered to Karth in July of 2020. After that time, he took no more involvement in the Karth counter-piracy operations. Mr. Magor was not in control and giving orders throughout the continuing crime in October of 2020 and can be distinguished from the cases cited by the prosecutor. And in contrast to the argument of the prosecutor regarding the loan of the weapons, Mr. Magor relinquished all control of the drones at the time, and all decisions on targets during the October 2020 events were in the discretion of the QHSF. The alleged crime we are here in court for today took place in October of 2020 with no legal connection to Mr. Magor. Additionally, under Article 11, personal jurisdiction cannot be satisfied because, as seen on the record page 2, Karth was not a party to the statute on any of the dates of the alleged criminal conduct, and there's no indication in the record Ibn has voluntarily consented to the jurisdiction at this point, and the UN Security Council has not referred Mr. Magor's case to the prosecutor. Turning to the defense's second point, the prosecutor asserts they have met their evidentiary burden of showing a substantial grounds to believe Mr. Magor aided and abetted in the alleged international crimes in Karth. However, the defense maintains that is not the case here because of the following 3 reasons. 1, contrary to the assertion the evidence is of sufficient probative value, the evidence presented is of low probative value, and it would be prejudicial to the defendant if the court were to consider it. 2, the alleged crimes did not rise to the level of war crimes or crimes against humanity. And 3rd, Mr. Magor lacked the mens rea to be found individually criminally responsible. First, both the UN and news report are of low probative value because they are unreliable and cannot be corroborated. This court has held hearsay evidence is only probative to the extent it corroborates other evidence on the record or is corroborated by other evidence on the record, as seen in the Katanga and Chui confirmation decision, paragraph 140. On one hand, only the news report directly implicates Mr. Magor in the alleged crimes in Karth contained within that report, as seen on the record pages 4 through 6. This document has a low indicia of reliability because the legitimacy of the facts contained within are directly in dispute in this case. Contrary to the prosecutor's argument of corroboration by this recantation, this is circular reasoning because you cannot use something that is unsubstantiated like the evidence of recantation due to bribery, to then corroborate something that is unsubstantiated, like the evidence contained within this news report. And we should not use Mr. McGore's case as a basis to initiate another investigation into witness tampering or bribery with something that is not connected to Mr. McGore. On the other hand, the UN report never makes any mention of Mr. McGore, and the defense is not asserting that it should be totally discounted because it could be a great representation of the circumstances surrounding the conflicts in CART, as seen on the record pages 3 and 4. But it never mentions Mr. McGore by name. As Chief Excellency pointed out in prosecutor's submission, to this day, more than a year since the article has been recanted by Cossain, the prosecutor has failed to provide the court with any further evidence substantiating the claims against Mr. McGore. Therefore, neither the evidence in the UN or the news report can be corroborated by additional evidence, as seen on the record pages 5 through 7. And as this court stated in the Nadaganda evidence decision, paragraph 12, it is the burden on the party tendering the evidence to provide the court with authentication and documentation that the sources are sufficiently reliable. And in the absence thereof, the chamber must therefore deny them high probative value. Turning to the second point on this issue, the elements of crimes cannot be satisfied because the crimes cannot be tried as war crimes or crimes against humanity. To begin, the defense would like to point out that an international or non-international armed conflict is necessary for Mr. McGore to be charged with war crimes. And if the prosecutor maintains there is no armed conflict in this case, then the defendant cannot have charges confirmed as such. Additionally, under the elements of the crime, Article 8, even if there was a non-international armed conflict in this case, the alleged acts cannot be tried under Article 8.2(e)(1) or 4 because civilians were not the primary objects of the attacks, and the buildings targeted, including the school and the hospital, were military objectives. Under the international humanitarian law principle of distinction, once juvenile pirates begin to use weapons, they are no longer a part of the civilian population and forego any sort of protections provided to them under international law. Therefore, 70% of the deaths during these week-long operations were legitimate military targets, as seen on the record page 4. And this court stated in the Katanga judgment, paragraph 802, where an attack is directed against a military objective and civilians are incidentally affected, those actions fall outside of War Crimes Article 8.2(e)(1). Therefore, the primary objectives of the attacks were not the civilian population, and Mr. McGore cannot be prosecuted under this article, regardless of any argument of proportionality. The attacks additionally were against the Pirates Supply Center, the Pirates Mothership, the school which the pirates took over as a hostage center, and the hospital where the pirates used medical personnel and patients as human shields, as seen on the record page 4. As Your Excellency posed in prosecutor's submission, all of the locations were in the hands or appropriated by the Taibosh at the time they were targeted, which would warrant a true military advantage if they were to be taken by the QHSF, making all 4 military objectives and outside the scope of Article 8. Moreover, the charged offenses cannot be tried as crimes against humanity because they were not directed against any civilian population as outlined in the Rome Statute Article 7.1, because as previously stated, 70% of the deaths during those week-long counter-piracy operations were legitimate military targets, as seen on the record page 4. To my third point on this issue, Mr. McGore cannot be held responsible under Article 25(3)(c) of the Rome Statute because he lacked the mens rea to aid and abet and be held individually criminally liable. As to actus reus, the defense does concede Mr. McGore was the supplier of weapons in this case. However, he did not possess the mens rea to aid and abet because under the Rome Statute Article 25(3)(c) and Article 30, the defendant must have acted with the intent or purpose to facilitate the crime and has to be aware of the consequences that would occur in the ordinary course of events. And as this court has previously indicated, this is a high standard of near virtual certainty, And as previously stated, the UN report is the single credible piece of evidence that outlines the alleged situation in Karth, as seen on the record pages 3 and 4. Based on the facts contained within the UN report, and even if the defense were to concede the facts contained within the news report were indeed true, as seen on the record pages 4 through 6, it is likely Mr. Magor knew there were juvenile pirates involved, but there is no indication he knew over half the pirates were juveniles, nor that civilians would be caught up in the hostilities. And under Article 32(1) of the Rome Statute, a mistake of fact can be an excuse for criminal responsibility if it negates this mens rea requirement. And the defense submits this lack of knowledge constitutes a mistake of fact because it negates this mens rea in this case. Additionally, the evidence provided by the prosecutor in this case is not indicative and probative as to the defendant's mens rea. Moving to my third and final point, one common victims representative is appropriate to advocate for all victims' interests in this case, because it would be prejudicial to Mr. Magor as an accused individual to have multiple victims representatives appointed. This court has a duty to ensure the trial is fair and expeditious and is conducted with full respect for the rights of the accused, as well as protection of victims and witnesses, as stated in the Kenyatta Victims Decision, paragraph 10. Additionally, this court has held in the Muthara and Kenyatta Victims Decision, paragraph 10, and has established that Article 68(3) of the Rome Statute does not give victims an unfettered right to participate in proceedings. Here, due to the nature of the alleged criminal acts, all of the victims in the present case suffered the same harm as a result of the Karth counter-piracy operation and would like to see the same result as it relates to the defendant in this case. Because the interests of the victims are not distinct and there is no conflict of interest to be avoided, cumulative evidence and evidence that is outside the scope of the proceedings could be presented, and the court has stated the accused should not be forced to address a large volume of views and concerns from victims that could go beyond the case of the prosecution, as was stated in Kenyatta, paragraph 13. Under the Rome Statute, Article 67(1)(c), and the ICCPR, Article 14(c), the multitude of evidence presented by multiple victims' representatives would cause undue delay with the progression and resolution in this case. For those aforementioned reasons, the defense respectfully asks this court to affirm the pretrial chamber's decision to deny the confirmation of charges against Mr. Magor and confirm the finding one common victims representative is sufficient to advocate for the needs of all interests. Thank you.
Thank you, Counsel. The bench has some questions for you, Ms. Chamberlain.
Thank you, Counsel. I have a question. The elements of crimes in paragraph 3, they state that the existence of intent and knowledge can be inferred from relevant facts and circumstances. And in this case, the suspect, he did know the effects and the potential of the weapons that he was providing to Karth. What is the defense submission in that regard?
Your Excellency, the defense maintains that the defendant did not have the mens rea to aid and abet in this case because the only probative evidence provided by the prosecutor in regards to that mens rea element is the UN report, which makes no mention of Mr. Magor. And even if the news report were to be admitted and be shown to have probative value, it is likely he had a general understanding of what was going on in Karth at the time, but was not aware of the specific places that would be targeted during these October 2020 counter-piracy operations, because his involvement in any sort of alleged criminal activity promptly ceased in July of 2020, as seen on the record pages 3 and 4.
Thank you, Madam Presiding Judge. Counsel, I have one question pertaining to the attack on the hospital. So the entire entire discussion regarding that attack on the hospital relies on the issue of military advantage or perceived military advantage versus the resulting collateral damage. So, could you enlighten us on the legal principles that are applicable in this situation, and also to what extent is it justified in this particular situation when for every two pirates that have been killed, there was one civilian death. There were 100 pirates killed, and there were 50 civilian deaths. So 1/3 of the casualties were civilians. So how can you justify this hospital as a legitimate military target with regard to all the legal principles that are applicable when targeting such institutions or objects? Thank you.
Your Excellency, as it relates to the hospital and the military objectives under the additional protocols of the Geneva Convention, while schools and hospitals are protective objects, they can be converted to military objectives in the cases where it would pose a significant military advantage to the QHSF to have those taken out of the hands of the Taibosh. And the defense maintains that was the case in the present altercation. And regardless of the principles of distinction of proportionality, additionally, the defense asserts that Mr. Magor cannot be held individually criminally liable in those particular circumstances because he was not the one making the decisions that the hospital or the school were the ones to be attacked, regardless of their military objective status.
Thank you, Counsel. All right, so that we will now go to the counsel for the victims. Counsel, please present your arguments to the chamber, and you as well have 20 minutes.
Madam President, Your Honours, may it please the Court. I appear as counsel for the victims in these proceedings. This case arises out of the crimes which were perpetrated in Carth in October 2020. From the 8th of October to the 11th in particular, the implementation of targeted drone attacks claimed over 1,000 lives on the small island nation of Carth. The government of Carth targeted the Taibosh pirates using lethal and indiscriminate drone technology, which was provided to them by the defendant, Mr. Agon Migor, for that very purpose. Madam President, Your Honours, the victims I represent comprise a diverse group of people. Firstly, I represent the families of the deceased adult pirates who were systematically wiped out by the deadly drones. Second, I represent the families of deceased juvenile pirates who were forcibly enlisted into the pirate ranks against their will. And thirdly and finally, I represent the non-pirate victims, including the hostages which were taken in the siege in the hospital and the elementary school, and those who perished in the wharf fire in Harbour Town. Persons who I submit were merely caught in the crossfire of these bloody attacks. On behalf of all the participating victims before the court, I will make the following submissions. Firstly, that Pre-Trial Chamber 6 erred in maintaining that a common legal representative is sufficient for the proper representation of the participating victims, and I will ground that submission in 2 points. Firstly, that there is an inherent current conflict of interests between the groups of participating victims in this case, and secondly, that no adverse effects to the fair trial rights of the defendant will be occasioned by the appointment of 2 additional legal representatives. My second submission to the court is that Pre-Trial Chamber 6 erred in refusing to confirm the charges against the defendant, Agon Migor, and I will once again ground that submission in 2 points. The first of which is that the actions of Carth, and by extension the actions of the defendant, are crimes against humanity under Article 71A, 71B and 71K of the Rome Statute. And secondly, that the situation in Carth is grave enough to make it admissible under the court's jurisdiction pursuant to Article 17(1)(d) of the statute. Turning to my first submission, and I note and agree with the prosecution counsel in that a common legal representative is not sufficient to properly represent the interests of the victims in this case. However, Madam President, Your Honours, I would extend the logic which he has submitted to the court in stating that no fewer than 3 representatives are required to properly give voice to the victims in this case. Firstly, there should be a representative for the families of the deceased adult pirates. Secondly, a rep for the families of the deceased juvenile pirates. And thirdly and finally, there needs to be a separate legal representative for all other non-pirate victims. There is a clear and obvious conflict of interests arising between the groups of victims in this case. The participating victims, pirates both adult and juvenile, have perpetrated violence against the non-pirate victims, most notably those who were taken as hostages and used as human shields in the various sieges in October 2020. In a similar vein, the adult pirates perpetrated violence against the juvenile pirates by forcing them to join the pirate ranks and abducting them. The court has recognised previously that where victims in a given situation have perpetrated violence against each other, there is an inherent conflict of their interests. And in the case of Katanga, the court chose to appoint separate legal representation for the victims who had been enlisted as child soldiers. And the court found that the fact that some victims had potentially perpetrated violence against others created an irreconcilable conflict of their interests. In this current situation, I submit that a very similar conflict of interest arises, as both the juvenile and adult pirates will have that conflict with the non-pirate victims. And similarly, the conflict between the adult and juvenile pirates will constitute a conflict. I submit that this conflict of interests has led the participating victims to request separate legal representation, and I further submit to the court that failing to respect the rights and wishes of the victims at this juncture will, at a minimum, cause re-traumatization to the victims. But I further submit that the prospect of common legal representation in a situation where there is active animosity between the victim groups may discourage victims from participating in the proceedings before the court at all. And this would create a barrier to justice for the victims and would be completely contrary to the spirit of the statute. Furthermore, there are other diverging views and concerns between the victims which warrant separate legal representation. The families of the Taiwash pirates, both adult and juvenile, belong to a distinct ethnic minority, and they deserve to have representation that will be sensitive to their cultural background. And I refer the court to the case of Benba and the pretrial chamber's 4th decision on victim participation at paragraph 11, wherein the court stated that it is advisable that legal representatives speak the victim's language, share their culture, and know their realities in order to properly effect their representation before the court. Furthermore, the juvenile pirates have distinct rights arising from their status as children before the court. And I refer the court to Rule 88.1 of the Rules of Procedure and Evidence, which stipulates that in respect of victims and their participation, special provision should be made for elderly persons, children, persons with a disability, and victims of sexual violence. I submit that the best and most expedient way to ensure that the children who are victims participating in this case have those additional rights met is to provide them with a separate and distinct legal representative. Moving to my second point, and that is that there will be no prejudicial effects to the fair trial rights of the defendant in this case, should 2 additional representatives be appointed. And the defence has cited delay as a cause for concern and a reason to deny the victims their desired mode of participation. While delay is certainly a matter of concern for all parties to the proceedings, victims included, it is submitted that no undue delay will arise from the appointment of 2 additional representatives. It is submitted that Article 68.3 of the Rome Statute is very clear in its terms, and that the participatory rights of victims are at all times subject to the absolute maintenance of the fair trial rights of the accused. And I submit to the court that the rules of procedure and evidence contain the requisite checks and balances to ensure that the trial chamber is the body which has complete control over the actual length of time that it will take for all victims to engage in their participation before the court. And in that regard, I draw the court's attention to Rule 91 of the Rules of Procedure and Evidence and paragraph 3, which states that when a legal representative attends and participates in accordance with the rule on behalf of victims, if they wish to question a witness, an expert, or the accused, the legal representative must make application to the chamber. Judges, it is submitted that at all stages of victim participation, the trial chamber is the appropriate person, or body rather, to place the requisite checks and balances to ensure that undue delay is avoided. And procedural safeguards are built into the rules of procedure and evidence for this very reason. Judges, I'll move now to my second submission, which is that the pre-trial chamber erred in failing to confirm the charges against the defendant, Aegon Migor. And firstly, judges, I wish to draw the court's attention to the fact that the prosecution has failed to address the charges levelled against the defendant under 7.1a, which is crime against humanity of murder, and 7.1k, which is the crime against humanity of
10 minutes left.
Other inhumane acts. And I would draw the court's attention to the obligation that the prosecution has under Article 54.1b of the statute to ensure the effective investigation and prosecution of crimes within the jurisdiction of the court. And Madam President, Your Honours, I submit that in order to ensure such effective prosecution, the prosecution should be addressing all of the charges which have been levelled against the defendant. In any event, I submit that the drone attacks perpetrated in October 2020 meet the relevant standard to be considered crimes against humanity under the statute, in that they consisted of a widespread and systematic attack and that they were directed against a civilian population. And I direct the court now to the decision of Pre-Trial Chamber 2 and the decision of the confirmation of charges in the case against Jean-Pierre Gombo Bemba. And I quote, "The Chamber considered that the term widespread connotes the large-scale nature of the attack, which should be massive, frequent, carried out collectively, and directed against a multiplicity of victims. There is no question but that the 4-day bombardment by hunter-killer drones constitute a widespread attack in Carth. The numbers of lives lost, for one, the spread-out nature of the attacks, and the absolute atrocities which were perpetrated are all evidence to this effect. And the defence doesn't dispute the fact that these attacks were systematic in nature. The evidence before us shows that over 4 fatal days, from the 8th to the 11th, 4 separate attacks were specifically carried out to cause the maximum amount of casualties to the Taiwash pirates. And this was carried out regardless of the collateral damage which would be caused to the civilian population. Furthermore, and importantly, it is my submission that the attacks were directed against an element of the civilian population in Carth, specifically the Taiwash pirates. And a civilian is defined as a person who is not part of an armed force or is any other kind of legitimate combatant. In the within proceedings, I submit that there was no non-international armed conflict at play in October 2020, and therefore all members of the Society of Carth, Taiwash pirates included, were civilians. Secondly, Madam President, Your Honours, I submit that the gravity of the situation is sufficient to render it admissible here under Article 17(1)(d) of the Rome Statute. It's submitted that the pre-trial chamber erred entirely in failing to apply the correct test and in failing to consider both the quantitative and the qualitative nature of the harm suffered in Carth. To address first the quantitative aspect of the gravity, if the court is minded to view the gravity of this situation on the number of deaths alone, I am minded to point out to the court that the pre-trial chamber in the Katanga decision confirmed the charges in situations where 200 victims had lost their lives. And furthermore, the pre-trial chamber one in the case of Abu Garda confirmed the charges in a situation where 12 African Union peacekeepers had lost their lives. In this instance, 1,000 persons have lost their lives. So, prima facie, there is no argument to be made to say that the number of victims on its own is not sufficient to meet the gravity threshold in this case. I refer now the court to the decision of the pre-trial chamber 2 in the situation on the registered vessels on the Union of Comoros, wherein contains what I say is the appropriate test to be considered. And paragraph 21 of their decision states that gravity must be assessed from both a quantitative and a qualitative viewpoint, and factors such as the nature, the scale, and the manner of commission of the alleged crimes, as well as their impact on victims, are indicators of the gravity of a given situation. Turning once again to the situation in Carth, the lives of 1,000 civilians were lost in these attacks. The damage caused was colossal, it was indiscriminate, and it was absolutely devastating for the inhabitants of the island. The manner in which the attacks were carried out by drone technology left the population of Carth completely helpless and unable to defend themselves in any way, shape, or form. And the repeated drone attacks were relentless. And there is no doubt, and it is not argued by the defence, that such attacks would have indeed continued until the pirates were completely eradicated, whatever the cost to the human life of Carth would be. Furthermore, I submit that protected buildings such as schools and hospitals were also targeted with no regard to the collateral damage that this would cause to the community at large. Madam President, Your Honours, while 1,000 lives were lost, the victim count far surpasses that number. The families of those who have lost their lives have suffered untold harm, and the legacy of this violence will shape the community of Carth for generations to come. Finally, the court also erred in failing to consider that the number of innocent victims was too small to warrant the admissibility criteria, and the decision of Pre-Trial Chamber 6 held that the number of innocent victims was too low to render the case admissible under Article 17(1)(d). And in that regard, it is submitted that there is no requirement for victims to be innocent under the rules of procedure and evidence. Rule 85 refers to a victim as any natural person who has suffered harm from the commission of any crime within the jurisdiction of the court. Innocence is not a requirement. Moral culpability in a general sense has no effect on the status of victimhood before this court. Notwithstanding this fact, the rules of procedure and evidence pledge to take into account the needs of all victims with particular protection for children. Therefore, the juvenile pirates should be afforded additional protection by the court owing to their particular vulnerabilities. Furthermore, the court has previously placed emphasis on the special status afforded to children under the UN Convention on the Rights of the Child in the context of recruitment of children in conflict. While innocence is neither defined by the statute or the rules, nor a requisite for victimhood, The child pirates are in fact especially protected by the provisions of the statute and the rules, and therefore to discount their lives for the purpose of the gravity threshold is unjustifiable. Your Honours, to conclude, it is the submission of the Victims' Counsel in this case that the PTC erred in failing to confirm the charges against the defendant Aegon Migor, and secondly, that they failed to give effect to the victim's request for additional legal representation. I respectfully submit and ask that the appeals chamber at this junction appoint 2 further victims' representatives and confirm the charges against the defendant, Aegon Migor. Unless I can be of further assistance, may it please the court.
Thank you, Counsel. We have a few questions. You've said that the juveniles are that is the juvenile pirates, are particularly protected under the law. My question to you is this. In relation to international criminal law and indeed international humanitarian law, what would be the position of a juvenile pirate who is actively participating in the skirmish, in the difficulty, in the war, in whatever is going on in that locality? Does that person have the same status as a juvenile who is not participating?
Yes, Madam President, thank you for your question. It is the submission of the Victims' Counsel that all juveniles who are enlisted in armed forces under international humanitarian law have the benefit of civilian status until such time as they actively participate in hostilities. In this instance, we do not have the requisite evidence to conclusively understand whether or not the juvenile pirates did actively and directly participate in hostilities. And in those circumstances, it's my submission that they enjoy the benefit of the doubt until proven otherwise, arising from their status as children and the protections that are afforded to them under international humanitarian law. However, it is also the submission of the Victims' Counsel that it is possible for child combatants to lose their civilian status by active participation. And it is not denied that this would have an effect on their protection should the court find that there is in fact a non-international armed conflict. However, I once again stress that it is the Victims' Counsel position that no such non-international armed conflict does exist.
Thank you. Ms. Jimberley?
Thank you, Madam President. Thank you, Counsel. I have no difficulty with the child pirates, but how are the families of deceased adult pirate victims how are they victims of eventually either war crimes or crimes against humanity? Considering that the pirates themselves, the adult pirates, they were armed, they used other people as civilian shields, as human shields, and they committed crimes themselves. So how can you, if you can elaborate your position?
Thank you, Your Honour. Yes, it is the Victims' Counsel position that the adult pirates were at all times civilians and at no time did they have combatant status because they simply do not meet the threshold to be considered an armed organised group within the meaning of a non-international armed conflict. It is submitted by the Victims' Counsel that the actions of the adult pirates at all times were those of criminals of bandits, and that it was appropriate for the Carth Homeland Security Forces only to act with the reasonable force that is allowable under international human rights law and not under the less stringent threshold of international humanitarian law. In that regard, it is submitted by the Victims' Counsel that irrespective of their crimes, and they certainly did commit crimes, that is not argued, they were civilians and they therefore fall to be considered as victims, as do their family members indirectly, because regardless of the actions of the adult pirates, their family members have lost loved ones. They've perhaps lost an income source. They have lost a part of their culture and heritage. And it is worth mentioning at this point that 700 Taiwash pirates were extinguished out of a population of 10,000 of the Taiwash clan. That's 7% of a minority ethnicity wiped out in these attacks. And it is in that context that I say that they fall to be considered as victims.
Thank you, Counsel.
Thank you, Madam President. Thank you, Counsel. So your position is that there was no situation of a non-international armed conflict in this particular circumstance. That would entail this chamber not overruling the trial chamber with regard to its rejection of the prosecution's charge of war crimes in the situation of a non-international armed conflict. My question to you would be, how does that impact the victims that you're representing, particularly the subgroups of victims that you're representing? Is it equally, does it affect all of those subgroups the same way? Or is there a conflict, or is there a contention between those subgroups? Thank you.
Thank you, Your Honour, for the question. And it is the Victims' Counsel submission in this regard that Your Honour has inadvertently hit upon one of the very reasons why a single representative cannot adequately represent all the victims, because it does make a difference to different groups of victims whether or not there is considered to be a non-international armed conflict. For example, the adult pirates are more likely to want to portray a non-international armed conflict because that will afford them greater protections, whereas the juvenile pirates and the non-pirate victims, it is more beneficial for them to assert that there was never a non-international armed conflict. And this is a fundamental difference in legal argument that's going to be played out before the court. And it is one of the very reasons why I say that 3 representatives are required to properly give rise to the voices of the victims.
Thank you very much.
Thank you, Counsel. All right, so we've received submissions and many important points have been raised. No doubt the parties would like an opportunity to reply to at least some of the issues raised. So in the same order, each party would be given the opportunity to reply, so that we would have first the prosecution, then the defense, and then the victim representative. May I remind you that this time you do not have 20 minutes, you have 10. Beginning with the prosecution, let me hear you, please.
Madam President, Your Honours, the prosecution wishes to submit 4 points in rebuttal against the defense as well as the Victims' Counsel. Before it starts, the prosecution wishes to clarify that although the prosecutor is in the general same position along with the Victims' Counsel, we may still object with your specific observations if errors of law was found within. as we have been doing such a vessel situation. Starting with our first ground of rebuttal concerning jurisdiction and the admissibility issue. Firstly, in response to the defense argument that the case is inadmissible for the reason that the number of innocent civilians was 300 and was too low, and that those killed in the police law enforcement was automatically justified. In this regard, we observe 3 errors of law. First of all, IHL only applies during an armed conflict, Your Honors, but defendant did not first discuss at all why in this case, there was a NIAC, and it is therefore submitted that they have not sufficiently fulfilled their obligation to prove that there was a NIAC and in their allegations. Second of all, we reiterate our primary position that the drone attacks in this case did not constitute a NIAC, not only because the pirates were loosely organized, as we have argued, but also because the drone attacks were just a one-side use of force instead of a two-way intensive conflict as required, such as in the ICTY Limarch case. And without such an armed conflict, all persons are civilians, including criminals, and the violence used against them can only be justified under the law enforcement regime and also under the international human rights law, which leads to our next argument, that these law enforcement did have arbitrarily deprived the right to life of the juvenile pirates and non-pirate civilians. If I may refer Your Honors to the practice by the principal legal systems in the world, such as the very recent Texas synagogue hostage incident this January, or even the most criticized Moscow theater incident in 2002, we see that weapons used for law enforcement must be precise light arms instead of any explosives. And more crucially, the primary purpose of those missions must be the rescuing of hostages and to avoid bystander casualties, instead of eliminating the suspect or criminal at all costs, which is what exactly the security force have done. It is therefore submitted that consistent with the Philippines authorization jurisprudence, that the drone attacks constitute an attack against the civilian population, therefore satisfying the key contextual element being debated today, and defendant cannot rely on the presumption of legality during a police law enforcement to justify any of those 1,000 casualties. Turning then to our brief ground of rebuttal concerning jurisdiction, that in response to the defense argument that the court's jurisdiction in this case was barred by Article 24. As Madam President must have been very familiar with your honorable participation in the same case currently at trial, as held by the appeals chamber in the Rahman appeals judgment, the legal effect of Article 24 of this statute is to exclude jurisdiction over conduct occurred before June the 1st, 2002, when the statute entered into force. It is therefore submitted, since the lease of drones totally happened after 2002, that article cannot exclude Your Honor's jurisdiction from this case, and that article is irrelevant. Turning then to our second ground of rebuttal, and in response to the defense argument that the evidence is insufficient, for their reason that the news report is a hearsay, and one such piece of evidence cannot support an allegation. However, Your Honors, at paragraph 53 of the Bamba confirmation decision, it has been held that one piece of direct evidence with sufficient probative value can support an allegation. The PTC in that decision defined direct evidence as those providing first-hand information. And in this case, the news article did provide first-hand information concerning a case-related fact that the security force commander admitted to the journalist that it was the defendant who leased the drones. The prosecution recalls that the standard of proof at the pretrial stage is lower than that at trial. And with this standard in mind, it is therefore submitted that the news article pointing to the above fact would be sufficient to bring defendant to trial as a direct evidence, as long as this evidence has sufficient probative value. And this leads to our second argument in response to defense, that the probative value of the news article is high, Your Honors, because it corroborated with another evidence, the UN report, not in the aspect of defendant's participation, but in many other aspects. The two of them are consistent with each other in many aspects, such as the place, time, targets of the attacks, and these consistencies would add up to the probative value of the news article to make it sufficient. And in any event, even if your honors are not satisfied with the evidence at present, pursuant to Article 61(7) of the statute, instead of ending this serious and ambiguous case at such an early stage, your honors may adjourn the hearing and request the prosecutor to provide further evidence or conduct further investigation, which is an approach that has been adopted by this court in the Rebuttal case. And we further wish to underline, your honors, that actually my office was given only 2 months from February to April 2021 from the impugned decision we could see to collect evidence before the confirmation hearing, which may be one of the shortest period of time given in all those 21 cases before this court against 47 defendants. Thirdly, and in response to the defense argument that crime against humanity of extermination was not committed, for the reason that the aider or abettor liability was not established. As for their facilitating purpose argument, we wish to underline that it was the defendant who proposed the provision of hunter-killer drones to the security force, and if he did not have such a facilitating purpose, he could have kept the existence of those drones as a secret from the security force. As for the alleged mistake of fact, this is a mistake of the defense argument has error of fact and law. First of all, on the fact, defendant was aware that the child soldiers will be attacked, since from the impugned decision we see during the conversation between defendant and the security force commander, they have frequently mentioned the relevant facts that the child soldiers were participating actively as most vicious of all, and they hid out in those schools and hospitals as a tactic to escape from the security force attacks. Second of all, on the law, in the elements of crimes, the inherent intent and knowledge under Article 7 should not be interpreted as requiring proof that the perpetrator had knowledge of all characteristics of the attack or the precise details of the plan or policy of the state organization, and is therefore submitted that those factual mistakes of fact cannot amount for the purpose of excluding criminal responsibility under Article 31. And we further question whether the defendant had a bona fide intent, that we see a worrying similarity between this case and the Spanish Civil War, where advanced and high-tech experimental weapons were knowingly provided to a notorious foreign government, and those violent weapons were eventually testified against human, especially civilian flesh and blood. Fourthly, and to give a reminder to the Victims' Counsel for the risk to propose an ethnic-oriented separate representation, and to reject the Defense Counsel and Victims' Counsel's substantive position that the identification of conflict of interest can only rely on existing jurisprudence. First, we disagree with the Victims' Counsel's position that ethnicity can be a ground of separate representation. The registry in Ruta and Sang has held that separating victim grouping along ethnic lines would only serve to reinforce ethnic divisions. And also in the Kenya cases, the registry again rejected to recognize ethnicity as a justification to separate victim representation. And more fundamentally, Your Honors, it is submitted that the identification of conflict of interest is not bounded on existing jurisprudence. And the relevant situation in this case is urging Your Honors to develop a new jurisprudence in this respect. I see my time might have been come up within...
Time is up.
30 seconds. May I be given an additional minute to briefly conclude?
Yes, no more than a minute, Counsel. Proceed.
Thank you. The legal provisions guiding such identification of conflict of interest, especially Rule 90, is implicit, Your Honors, and the Court has already been creative in its relevant orders and decisions in interpreting conflict of interest, as long as such interpretation is consistent with the Court's legal framework, such as the two existing modes of conflict of interest, which has been generally agreed upon by all three parties today. The prosecutor noted that the Court's general obligation under Articles 68(1) of the statute that it shall take appropriate measures to protect the safety, dignity, and privacy of the victims, It is therefore submitted that in this case, since the deceased pirates were at least partially responsible for the non-civilian death, arranging their families together with their hatred against each other may threaten their such safety, dignity, and privacy that the court shall protect. And in order to realize such protections, Your Honor may establish a new jurisprudence to justify separate victim representation in this case.
Time
And
is
this
up.
concludes the prosecutor's rebuttal, and may it please the court.
Thank you, Counsel. We have one question for you.
Thank you, Madam President. And just a short question. So it's the position of the prosecution that there was no situation of a non-international armed conflict in the present case. If that is the situation, is the prosecution dropping the charge of war crime?
It is submitted that we're making alternative charges in this respect. And our primary argument would be that there was no NIAC in this case, and that those deaths cannot be justified by IHL. And we adopt this preliminary ground in order to include as many victims as possible. And secondly, if Your Honors are not satisfied with our first argument that from your perspective there was a NIAC, we would instead charge defendant with both crime against humanity and war crimes, albeit with less possible victims.
Thank you.
All right, thank you, Counsel. We now go to the defense team for its rebuttal. 10 minutes, please.
Your Excellencies, may it please the Court. In this rebuttal, the defense would like to discuss two issues: jurisdiction and the evidence in this case. To begin, Madam President pointed out in prosecutor's submission that it is the prosecutor's burden here today, and the defense maintains they have failed to meet that burden. This burden includes proving the elements of the crimes they charge. It is important for this court to note, if there is not a non-international armed conflict, as both the prosecutor and victims' counsel has maintained, Mr. McGore cannot be charged with war crimes because it is a necessary requirement under Article 8, Elements of Crimes. And it will be improper to confirm charges as it is the prosecutor's burden to show that there is a non-international or an international armed conflict, as their office is the one bringing the charges. However, as the appeals chamber acknowledged in the Al-Hassan admissibility decision, paragraph 46, any issue as to the admissibility of a case or the jurisdiction of the court must be resolved before consideration of the merits of a case. First, under Article 24.1, jurisdiction cannot be satisfied if the alleged criminal acts took place before the state became a party to the statute, and the Rome Statute cannot have retroactive effect. In contrast to the argument of the prosecutor, this is not a continuing crime because the conduct in this case is instantaneous, and the language of Article 24 is to be interpreted differently. Mr. McGore's conduct and participation in any sort of alleged criminal activity promptly ceased when the drones were delivered to Karth in July of 2020, as seen on the record page 5. Conduct as it is used in Article 24 of the Rome Statute should be construed to its plain meaning, as the court should utilize the Vienna Convention on the Law of Treaties, Article 31, which says as such. Plain meaning of conduct indicates conduct is the delivery of the drones rather than the facilitation of any military operations. The court must take this more restrictive approach because the principle of legality under Article 24.2 of the Rome Statute states that everything ambiguous must be construed in favor of the defendant. Secondly, the prosecutor has failed to meet its heightened evidentiary burden before the court of showing the pretrial chamber misappreciated the facts. The prosecutors have not provided this court with sufficient evidence to establish a substantial grounds to believe Mr. McGore did indeed aid and abet in the alleged crimes in Karth. As the prosecutor has correctly stated, hearsay evidence can be probative, and one piece of evidence can be sufficient to confirm guilt, but only if it is of high probative value and can be corroborated, as seen in the Katanga and Chui confirmation decision, paragraph 140. Only the news report directly implicates Mr. McGore in the crimes in Karth as contained within the report, as seen on the record, pages 4 through 6. This document has a low indicia of reliability because the legitimacy of the facts contained within are directly in dispute. There is simply no evidence beyond what is circumstantial in this case to show that there was any sort of bribery. And there cannot be corroboration by recantation as the prosecutor has submitted, because this is circular reasoning. You cannot use something that is unsubstantiated, like a claim of bribery, to then substantiate the evidence contained within the report, which is of low probative value because it is unsubstantiated. The defense is not saying the UN report should be totally discounted, because it may be a clear analysis of war crimes in Karth, but mentions nothing of Mr. Magor personally, as seen on the record pages 3 and 4. The prosecutor has asked this court for more time, but they have had a year and have procured no more evidence to substantiate the claims it has made against Mr. Magor, as seen on the record pages 5 through 7.
5
Moreover,
minutes
it
left.
would be prejudicial to have this evidence given high probative value against the defendant, because it would undermine the procedural integrity of these proceedings. The court instructed in the Nadaganda evidence decision, paragraph 12, it is the burden on the party tendering the evidence, which in this case is the prosecutor, to provide the chamber with sufficient information to assess the reliability of the items it requests admission of, and in absence of any further information or authentication, these documents are not sufficiently reliable or probative, and the chamber must therefore deny them probative value. If this burden of proof were to be lowered, it would open the floodgates, so to speak, and the defendant's rights as an accused individual would be severely compromised in this case and possibly in any forthcoming cases. And for those aforementioned reasons, the defense respectfully asks this court to affirm the pretrial chamber's decision to deny the confirmation of charges against Mr. Magor, and if this case were to proceed, confirm the finding one common victims representative is sufficient to advocate for the needs of all interests. Thank you.
Thank you, Counsel. We have one question for you. Mr. Ahmed?
Thank you, Madam President. Counsel, if the chamber were to rule that the news report is reliable and does have probative value, how would that affect the defense case?
Your Excellency, the defense still maintains, regardless of if the news report does have high probative value, the court does not have jurisdiction to prosecute Mr. Magor, nor that it meets the gravity requirement under Article 17(1)d of the Rome Statute. However, if both of those admissibility and jurisdiction elements are to be met,
how does that affect the content? Sorry, my question was about the content of the news report. If we deem it to be reliable and probative, what is the defense submission about the content of the news report?
Your Excellency, in regards to the content of the news report itself, the defense still maintains that it is not of sufficient enough content to satisfy the mens rea element of Article 25(3)c of the Rome Statute, and therefore Mr. Magor still cannot be found individually criminally liable for the acts in Karth.
Thank you, Counsel. All right, so
Thank you.
We now go to the legal representative of the victims to have their rebuttal of 10 minutes.
Madam President, Your Honours, may it please the Court. I have just 3 brief points of rebuttal to present at this juncture. My first point of rebuttal is in respect of the non-international armed conflict which the defence has tried to establish. Secondly, I too will address the point relating to the evidence which has been put before the court. And finally and thirdly, I will once again lay out my reasoning for 3 victims' representatives in this case. Turning firstly to the defence's assertion that there is a non-international armed conflict. And the defense has asserted that in order to rely on international humanitarian law, which they have so heavily done throughout their submissions, a non-international armed conflict must have been in situ in Carth in October 2020. However, the defence have completely neglected to establish, for the reasons set out in the decision of the Appeals Chamber in Tadich, that the requisite criteria to establish such a non-international armed conflict are present in this case. And the criteria in Tadich, as the court will be aware, are both the intensity of the conflict and secondly, the organisation of the armed group. Madam President, Your Honours, I intend to focus this rebuttal on the organisation of the Taiwash Pirates as a group. We are aware from the evidence in the UN report that they are a group of 700 strong individuals. They have no discernible chain of command. They don't seem to have a name. They don't have any known leaders. Their one distinguishing link is that of their ethnic background. I refer the court to the case of Gabo and the pre-trial chamber's finding in respect of what it means to have responsible command as an armed group. And the pre-trial chamber found that responsible command entails some degree of organisation of the armed groups, including the possibility to impose discipline and the ability to plan and to carry out military operations. Judges, I turn to the facts of this case. Leading up to October 2020, there was a pattern of skirmishes off the Carth coastline, wherein the Taiwash pirates attacked cargo ships and dozens of persons were lost in the various skirmishes. They're described as sporadic by the UN High Commissioner's report. Your Honours, I submit that there is no evidence to suggest that the 700 killed pirates were all acting in tandem as one unit, one armed group. It is far more likely that they are numerous criminal gangs operating completely independently of each other, and that they have been rounded up to a single organised armed group by the defence in this case, simply so that defence can profit from the less stringent controls imposed upon them by international humanitarian law. It is the Victims' Council's position that there was never a non-international armed conflict in progress in October 2020, and that the Carth Homeland Security Forces were at all times bound by international human rights law. In particular, I'd like to make reference to the International Covenant of Civil and Political Rights and Article 6 thereof, which gives a complete ban on arbitrary losses of life. And the failure to respect Article 6 in the context of peacetime, which it is submitted that was in train, is the most grievous of violations of the International Criminal Code. Moving to my second point of rebuttal, and this is in respect of the evidence which has been placed before the pre-trial chamber. And the Victims' Council is in agreement broadly with the prosecution in that the evidence is sufficient to meet the reasonable grounds to believe standard which is required to confirm the charges. However, the Victims' Council has a further observation to make in respect to the evidence to put before the court. And it is in respect of the high degree of corroboration between the two pieces of evidence which the court has had sight of, that is namely the report of the UN High Commissioner and secondly the article of Roger Costain.
5 minutes left.
The article of Roger Costain, it falls to be considered, was written and published 1 month before the publication of the UN High Commissioner's report. And I draw the court's attention to that fact so that the possibility that Roger Costain had sight of the UN High Commissioner's report can be completely excluded. Furthermore, the details of the report of Roger Costain are uncannily accurate in respect of the nature of the drones, the dates and locations of the attacks which took place in Carth, the description of the victims, and furthermore, the actual position that the defendant himself possessed and its uniqueness in terms of access to such high-level weapons of this nature. Furthermore, it falls to be considered by the trial chamber that the drones implemented were specially developed by Ibn. They were at all times unique and easily identifiable as the product of Ibn. Finally, judges, I would like to reiterate my submission in respect of the number of victims' representatives to be allowed participate. Both the defence and the prosecution have spent far too little time in dealing with the matter of victim representation before this court today. And that bolsters my submission that it is even more important that the court give the victims their 3 separate legal representatives. And judges, if I might take the court to the very first line of the preamble of the Rome Statute, and I quote, "Conscious that all people are united by common bonds, their cultures pieced together in a shared heritage, and concerned that this delicate mosaic may be shattered at any time." Madam President, Your Honours, it is my submission that the drafters of the Rome Statute understood that placing victims at the centre of the proceedings at the ICC was a means to reconciliation for all in the face of the gravest of international crimes. On that note, I urge the court to appoint 2 additional legal representatives for the victims and further to confirm the charges against the defendant, Aegon Migor. Unless I can be of further assistance, may it please the court.
Thank you. Very well, Counsel. All right. How long do we wait? Yes, I think so. Farhan. All right. So thank you, all of the parties, for your substantial submissions. We will now take them all into account. We will leave the court and deliberate, I think perhaps up to 3:45, yes, so that you are to keep yourselves in a manner that would make it easy for you to reappear in court on or before that time. Yes? Very well. All right then.
All rise.